Who has to pay an award in a New Jersey sexual abuse lawsuit when there are multiple defendants who are deemed to be at fault? My name is attorney Ben Andreozzi, and my firm, Andreozzi & Foote, represents survivors of sexual abuse against institutions and organizations who allow and enable abuse. I'm licensed to practice in New Jersey. One of the questions that I often get is, how do you determine the amount that each defendant owes in a New Jersey sexual abuse case? Well, in the state of New Jersey, the fact finder, who's either a judge or a jury, has the job of determining the degree and extent of fault of each of the individual defendants. They then apportion a percentage of fault to each one of these defendants. For cases that arise from abuse that happened after 1995, New Jersey has what's called a modified version of joint and several liability. And under that modified version of joint and several liability, if any individual defendant is deemed to be 60% or greater at fault, that defendant can have the responsibility of paying the entirety of the judgment. For sexual abuse that happened in New Jersey, between 1987 and 1995, the law requires an individual defendant to have at least 20% responsibility to be on the hook to pay for the entirety of the damages that are awarded. And prior to 1987, New Jersey law allowed plaintiffs to recover an entire amount of the jury verdict from a single defendant who was found to be 1% or greater at fault. And this is a complicated issue. If you have questions related to sexual abuse litigation in New Jersey and whether a defendant or multiple defendants can be responsible, and if so, how much in damages each one might owe, please feel free to email my law firm. You can reach us at info@vca.law, or for more information, you can visit our website, which is www.victimscivilattorneys.com.